Stand your ground laws in Georgia, pros, cons, and misuse risks. Introduction. Stand your ground laws are one of the most controversial and debated regulations in the United States. Stand your ground laws grant individuals the right to hold their ground and use deadly force for self-defense purposes if they reasonably believe it will prevent great bodily injury or death. The use of deadly force in such cases is allowed both in private residences and in public, regardless of whether a safe retreat is available for the person in the position of self-defense. This paper will provide a brief overview of stand your ground laws in Georgia, examine their advantages and disadvantages, and discuss the potential for victims to be provoked and killed under these laws. History of stand your ground laws in Georgia. Stand your ground laws have been implemented in numerous states in the U.S., giving civilians the right to protect themselves against physical harm and death with the use of force available to them. Contemporary stand your ground laws, alongside other laws outlining self-defense and protection of property, originated from common law, referring to laws brought over from England to the United States. The circumstances allowing for self-defense, as well as the degree of acceptable force, are determined by state governments. No common law, including self-defense laws, is acknowledged at the federal level. Therefore, although applicable in most states, stand your ground laws may differ substantially throughout the country. The state of Georgia was among the first states to adopt stand your ground laws. The state enacted the laws in 2006, allowing civilians to protect themselves, others, and their property against substantial threats, including physical threats. In Georgia, the law indicates that individuals are not obligated to retreat from a threat, even if it is a viable option that may result in de-escalation of the situation. Furthermore, the law emphasizes that deadly force should only be used if there is a reasonable belief of imminent physical injury or death. If deadly force is used, the law offers immunity from criminal prosecution, inapplicable only when the weapon is in illegal possession. Overall, the stand your ground law in Georgia removes the duty of retrieval before the use of force and ensures legal immunity for individuals acting in self-defense against threats. Advantages and disadvantages of stand your ground laws. The stand your ground laws are associated with a variety of advantages and disadvantages. The advantage of the law is that it allows individuals to protect themselves against the commission of a crime while ensuring that they will not be prosecuted by law for exercising their right to self-defense. Furthermore, the no duty to retreat clause ensures that civilians can protect themselves, even if there is a practicable opportunity for retreat. This clause can be of particular value to women, older adults, and other individuals who cannot retreat. From this point of view, the no duty to retreat stand your ground laws offer protection for the most vulnerable in the community. Nevertheless, the disadvantages of stand your ground laws may outweigh their advantages. Thus, the legal immunity from prosecution removes any incentive for the de-escalation of the situation or alternative solutions to it, leading to unnecessary loss of life if deadly force is used. Furthermore, the law gives civilians unrestrained power and discretion as it allows them to judge their situation and whether the threat is immediate. Although the stand your ground laws may be misapplied, they do not cover all threatening circumstances civilians may find themselves in, as they do not cover crimes in which individuals' lives are not immediately threatened. Potential for misuse. While it is essential to ensure that individuals have the opportunity to protect themselves without the fear of legal repercussions, stand your ground laws may be misused to commit violent crimes against others. As the foundation for the use of violence lies in one's judgment of what immediate threat constitutes, situations may be misunderstood and fabricated to provoke people and commit crimes against them, claiming stand your ground laws. According to Perez and Sower et al., stand your ground laws are routinely brought up as a defense in homicide cases. It should be noted that a substantial proportion of such cases deals with the use of violence against people of African American descent by white defendants. In addition, people may be verbally provoked to attack, with the initial attack being used as grounds for the use of force against them. Thus, stand your ground laws can be weaponized by people to use deadly force against others by claiming that a threat to their own life and safety is imminent and unavoidable. Conclusion. Overall, it can be argued that a more balanced approach to self-defense is necessary. Although stand-your-ground laws ensure that civilians have the right to protect themselves against violent crimes, there is an opportunity for misuse and misinterpretation. Furthermore, individuals may intentionally provoke an altercation to be able to use deadly force against others by giving rise to a situation in which the victim is the initial attacker. Meanwhile, research indicates that the adoption of stand-your-ground laws is associated with an average increase in violent crimes of over 10% in numerous states, including Georgia. To avoid such cases, it would be sensible to reinstate the duty to retreat when appropriate to prevent abuse of the law. This would be a prudent step as it would impose a legal requirement of an attempt to retreat on physically capable individuals exercising their right to self-defense, preventing many cases of provocation and incitement.